everyone, this is Lonnie Misalucha and you are listening to PHLV Radio.
PHLV Radio.
Reeves Immigration Law Group now brings you immigration law on your side.
All right, thank you for joining us here on Immigration Law on Your Side, right here at PHLV Radio. Ako po si Kuya Yo dito sa PHLV Radio Studio sa Las Vegas, Nevada. And of course, kasama po natin si Attorney FJ Diza. Nandyan po sa Reeves Immigration Law Group. Dyan po sa San Francisco, California. And mga kababayan, maganda po ang pag-uusapan natin ngayong gabi because if you are or any of your friends or relatives are in deportation, meron pong magandang balita coming from the Supreme Court. Pag-uusapan po natin yan mamaya. Kaya tamang-tama din po ang ating topic ngayong gabing ito is about the cancellation of removal. And ito pong decision nga galing sa Supreme Court. So pag-uusapan po natin yan mamaya-maya po lamang. And again, welcome po sa Immigration Law on Your Side. It's another Wednesday night here in the East Coast, 7 p.m. na naman. I mean, West Coast, 7 p.m. na naman. Mga kaibigan, being placed on deportation proceedings is really scary. And of course, very stressful for immigrants. But, you know, success in immigration courts is not impossible. Kaya ipapaliwanag sa atin ni Attorney Diza ngayong gabi kung ano ang mga relief at ano ang pwedeng gawin para po naman ma-cancel ang iyong removal kung ikaw ay nasa deportation na. So let's bring in Attorney FJ Diza from Reeves Immigration Law Group in San Francisco, California. Magandang gabi po sa iyo, Attorney Diza.
Good evening, Kuya Yo, and of course sa lahat ng mga viewers and listeners natin, Miyerkules naman po at maraming salamat sa inyong pakikinig at panonood sa amin ni Kuya Yo at sa aming public service, Immigration Law on Your Side. And as you mentioned, marami rin sa ating mga kababayan dito sa Amerika na nasa removal proceedings, Kuya Yo, dahil at one time, you know, they have applied for immigration benefits at sila na-deny, right, or they committed a crime and they were placed in removal proceedings. And of course, very timely ang ating pag-usapan dahil gagamayin natin kung ano yung mga posibleng relief at depensa kung sila po ay nasa removal proceedings or deportation proceedings. Isa nga ito ang cancellation of removal na ating pag-uusapan ngayong gabi. Mainit na topic mga kaibigan. Siyempre pag sinabing cancellation of removal, medyo good news ito. So stay tuned. We will be having some updates at the end of the show. But in the meantime, let's define, Attorney, paano po ba ito? Itong cancellation of removal, paano po nangyayari ito, Attorney, despite the fact that you're already in deportation? Yes, the cancellation of removal is one of the many relief if one is placed in a removal or otherwise known as a deportation proceedings, Kuya Yo. It is available sa mga non-US citizens, siyempre, but applicable for both yung non-immigrants at also yung mga green card holders. And if they were placed in removal proceedings, this is a form of relief, Kuya Yo. And if the judge grants this form of relief, kakancel po ang kanilang removal and they would remain in the United States as a green card holder. So ito po yung isa sa mga paraan para sa depensa po ninyo. But there are other ways na pag-usapan natin in the future. For example, adjustment of status through a family-based petition, employment petition, asylum. You know, pero magpo-focus po tayo ngayon sa cancellation of removal dahil nga dun sa nabanggit mo, Kuya Yo, na US Supreme Court decision na very timely at ma-discuss natin dahil maraming matutulungan na mga kababayan natin who are currently in proceedings or kahit na yung mga nagkaroon na ng decision, Kuya Yo, pwede pang i-avail itong bagong Supreme Court decision na ito. But nonetheless, as you mentioned, may mga iba't ibang klase ng cancellation of removal. Ito'y para sa mga green card holder. Right? Ito'y para sa mga nag-overstay na or wala ng status. At pangatlo, pwede rin ito sa mga battered spouse. So ito yung tatlong classification ng cancellation of removal.
Attorney, saan po ba ito ina-apply? Is it applied sa immigration office?
No, this is not an affirmative application, Kuya Yo, at sa mga kababayan natin. This only applies kung kayo po ay nasa deportation proceedings na, right? Kung nandun na po kayo mismo maharap sa immigration judge at kayo po dideport na ng gobyerno, then you can probably or possibly apply for this kind of relief known as cancellation of removal.
Mhm. So, attorney, mabigyan natin ng konting kumbaga snapshot ang ating mga listeners and viewers. What are the requirements for the cancellation of removal? Para sa mga permanent residents muna, attorney.
Yes, yung mga kababayan natin, marami sa atin na akala pag nakuha ng green card, okay na po kayo sa US. Di po ba? So, but keep in mind na pag kayo you commit a crime, or if immigration found out that you also committed fraud, then the Department of Homeland Security or even the Department of Justice can issue the notice to appear, right? Tinatawag natin na parang charging document where they charge you of committing a crime, right? And therefore you are deportable. So wag po ninyong what do you call this, magkampante na green card holder na ako, I can stay in the US hanggang kailan ko gusto. That's not a good, hindi po yung tama, because anytime the government can issue you a notice to appear and can deport you to your home country. So isa sa mga importanteng requirements, Kuya Yo, is number one, that the green card holder has been a green card holder for 5 years or more. Now has been a resident of the United States for over 7 years. So for example, before getting the green card, they were in the US in other non-immigrant capacity. Halimbawa, tourist visa sila, or nandito sila on an H-1B visa or other form of non-immigrant status, right? So 7 years residency. And then of course, kailangan din po na walang conviction of an aggravated felony. So very important yan, right? Kasi let's say you commit a crime, hindi po dapat tinatawag na aggravated felony, which is defined as any kind of a serious offense where the penalty is more than 1 year imprisonment. So it's also very important sa mga kababayan natin na green card holder at mayroong serious charges to consult with an immigration attorney bago po kayo makipag-plea, right? Sasabihin sa iyo ng defense attorney ninyo na hindi ka naman makukulong, or sa kulungan ka lang is nasa 1 year lang, umamin ka na or mag-plead guilty ka na. So in that situation, if the plea is and the conviction rather is more than 1 year, then you are precluded from applying for a cancellation of removal. So those are the very important qualifications or requirements, Kuya Yo. Very common dyan sa mga kababayan natin ang domestic violence, right? So for example, even if the penalty is not less than 1 year, it's called deportable offense, right? So for example, na-convict yung isang Pilipino, right, na green card holder ng domestic violence, at ang kanyang imprisonment is only like 6 months, right? Or for example, petty theft, nagnakaw, nag-shoplift, right, at merong penalty na more than 6 months. Fraud, for example, yung mga ganyang sitwasyon, Kuya Yo, where as I said, the penalty or the imposition of the imprisonment is not more than 1 year. So pwede po sila mag-avail ng cancellation of removal. So if the judge grants you the relief, babalik po kayo sa pagiging green card holder yo, and hopefully, after the passage of time, you're able to establish good moral character, pwede na po kayo mag-apply ng naturalization or tatawag nating citizenship.
Yung nabanggit yung naturalization, attorney, normally kung naghihintay ka ng 5 years, nagkaroon ka ng ganito, say for example on your 2nd year, tapos na-reinstate yung green card mo dahil nag-grantan ka nito, bumabalik ba yung bilang ng 5 years na babaliwala yung unang 2 years mo, for example?
Well, unfortunately, Kuya, you can only avail this one-time relief. So let's say you were convicted of a domestic violence previously, nag-avail ka, they just granted you this form of relief, right? I-reinstate sa yung green card mo, binidlik sa yung green card mo, and you committed another offense, then that's going to be a very difficult, defense. And I would strongly recommend that, hold off muna ang pagpa-file ng citizenship mo. But of course, anytime, the government, can always issue another notice to appear for you to appear before the immigration judge. So sa mga kabayan, a reminder sa inyo na even if the judge granted you the relief, right, make sure that you don't commit any more serious crimes dahil, you're only given one time, relief. Kasi otherwise, sa susunod mong punta sa judge, wala na, hindi ka nabibigyan ng this form of relief.
Mhm. Okay. How about attorney, yung mga non-immigrant naman po o yung mga non-permanent residents na nasa deportation, ano po naman yung mga requirements sa kanila?
Very common to, Kuya Yo, yung mga kababayan natin na pumasok, di ba, na as tourist visa and then nag-overstay. So assuming meron pa silang mga petition sa mga magulang nila na naghintay ng mga 18 years, 20 years, right? Unfortunately, they are unable to get the green card pag sila overstay. So, but for example, if they're in proceedings and they're taking care of their ailing parents, this is a good form of relief, right? So, unang-una dyan, Kuya Yo, is the 10 years physical presence in the US. So, titignan dyan kung kailan po kayo pumasok sa Amerika. So, those people who entered before 2011, right, at sila nasa immigration judge na they're able to avail yung this form of relief na tinatawag natin cancellation of removal for non-lawful permanent residents. Pangalawa would be yung there's no aggravated felony as well. So walang serious crime na na-commit. Pangatlo, which is very important na wala sa mga green card holders, they don't have to prove ang cancellation of removal para sa mga non-immigrant or non-green card holders, kailangan nilang magkaroon ng qualifying relative, Kuya Yo. This is a very difficult aspect ng application because yung client who's in proceedings, kailangan meron siyang asawa or meron siyang anak, right, below 21, who would suffer extreme, exceptional, unusual hardship. So the extreme hardship standard is very, very high. So it's up to the ceiling, right? Hindi kagaya yung pinag-usapan natin previously where yung 601 waiver, yung you commit a fraud and you file a waiver for misrepresentation where you have to prove extreme hardship lang. But in a case of cancellation of removal, the extreme hardship is super high, right? So extreme, exceptional, unusual hardship. So, ibig sabihin ng Kuya Yo is yung, let's say, yung magulang po ninyo ay merong serious medical condition that requires kind of like around-the-clock treatment or pagbabantay, kailangan i-prove nyo na kayo lang ang available na family member who take care of your ailing parent, ailing spouse, or children who has serious medical condition, yung mga special children na kailangan nasa US sila rather than nasa home country ninyo. So ito yung mga requirements, Kuya Yo, ng what do you call this, ng cancellation of removal for non-permanent resident. Of course, they also have to show that they are a person of good moral character, right? So ibig sabihin that aside from no serious criminal conviction, they also are contributing to their taxes. You know, they're working and they are filing their taxes and paying their taxes, and they are taking care of their children. They're contributing. They're voluntary. Nagvo-volunteer sila sa mga school activities ng anak nila or any of the religious or non-profit organizations. So they have to show good moral character in order for the judge to grant itong discretionary relief na cancellation of removal for non-permanent resident. So ito yung mga qualification, Kuya Yo, ng cancellation of removal for non-permanent residents.
Being non-permanent resident attorney, even the future nagkaroon sila ng sponsor, for example, nasa deportation proceeding sila at nabigyan sila ng relief as non-permanent residents, will they be qualified to become permanent residents if, for example, merong mag-sponsor sa kanila ng green card, attorney?
Well, the good thing about this relief, Kuya Yo, is that if the judge canceled yung removal mo, makakukuha na sila ng green card. So they don't have to find ways to get the green card already, right? So yun yung kinaganda ng cancellation of removal, because if the judge said, okay, because of your relief, right, you've been in America for 20 years, 15 years, your parents should suffer hardship, extreme exceptional hardship, you're a good moral person, I'll grant you the relief, right? So maghihintay lang ng visa availability, Kuya Yo, and then the applicant would be able to get the green card already. So hindi na nila kailangan ng sponsorship kung sila po napigyan na ng green card, because essentially if the judge grants the relief or the cancellation of removal, then they are considered as a green card holder.
Kaya mahalaga yung palang sinabi nyo kanina that you're starting anew, kumbaga. So make sure you take care of it and don't commit any any more any other thing that might make you lose your green card again. One time lang pala ito, attorney. Attorney, nabanggit nyo kanina yung mga period of stay ng mga mag-avail ng cancellation of removal. Nakita ko merong itong tinatawag na stop time rule. Ano po ba ito, attorney, na rule na ito?
Yes, Kuya Yo. Doon sa mga green card holder, ano po. So let's say nabigyan ko yun ng green card or you're able to receive your green card in 2010. Right? And then if you commit a serious crime, right? Then it stop yung counting mo. Kasi ang requirement natin doon sa ating green card holder is 7 years, di ba? 7 years physical presence or 5 years as a green card holder. So for example, on your 3rd year as a green card holder, you committed a crime na considered deportable. You cannot avail, Kuya Yo. You cannot avail of the cancellation of removal. Right? So for example, 2010, nakuha mo yung green card holder. Juan de la Cruz obtained the green card holder, received the green card holder. 2013, he committed a domestic violence, which is deportable offense. So walang nangyari sa kanya, right? So wala hindi siya pinansin ng gobyerno. So ngayong 2020, ngayon lang siya dinideport. Or let's say, panahon ni Donald Trump, maraming ganyan. Tinignan yung mga criminal records and then saka lang sila nag-start ng removal or deportation. So 2020 na tayo ngayon. So isipin mo, 20 years na nandito so he can avail of the cancellation of removal. Now the answer there is no, because the moment the immigrant committed the serious crime, which is domestic violence in 2013, 3 taon lang yon, Kuya Yo. So he's disqualified. Nag-stop yung time at that point. So 3 years lang yung na-accumulate niya. So therefore, hindi niya ma-avail yon. So sa mga kababayan natin, if you intend to commit a crime, wag naman sana, palagpasin niyo yung 5 or 7 years kung kayo green card holder. But nonetheless, the advice there is don't commit any crime. Now, doon sa naman, Kuya Yo, the same thing with the green card, doon sa mga non-immigrant o yung mga wala pang status, yung mga out status. Right? So for example, the same person, Juan de la Cruz, entered the US in 2010. Right? Wala siyang crimes, wala siyang ginawa, right? But unfortunately, immigration went after him. So 2009, nag-issue na sila ng notice to appear. Like, you need to see a judge because you already overstayed your visa. So in that situation, Kuya Yo, 9 years pa lang from the time of his entry, nag-stop na yung time. Doon naman yung notice to appear sa kanya, in-issue na ng notice to appear, nag-stop na yung time. So kahit 2020 na tayo ngayon, right, 20 years na nandito, hindi pa rin siya makapag-avail ng cancellation of removal because he was issued a notice to appear, right, in less than 10 years. Ang notice to appear po, ito yung piece of paper, is a document where the government charges you of the immigration violation, right? Sasabihin nila, you are Juan de la Cruz, you entered the US on a tourist visa in 2010, January 1 of 2010, valid only until June of 2010. Then you overstayed your visa and therefore you are deportable. So pag nag-issue sila ng ganyang charging document or known as the notice to appear, then hindi nila ma-avail ngayon. So itong discussion natin magiging relevant mamaya doon sa decision ng Supreme Court, Kuya Yo, dahil itong notice to appear na to dapat mayroong certain format, di ba? O mayroong mga informations na dapat nandoon. Kasi kung kulang yung information na yon, it's considered defective and therefore hindi yan considered as notice to appear and therefore kahit may issue yan, na wala pa kayong 10 years, considered invalid po yun and hopefully, you already accumulated the 10 years by the time that you see a judge.
Mga kaibigan, we mentioned that on top of the program. For those who are just joining us right now, Immigration Law on Your Side right here at PHLV Radio, brought to you by Reeves Immigration Law Group. Nandun si attorney sa San Francisco, California. Ako naman nandito sa Las Vegas. On top of the program, we told you that there was a Supreme Court decision. April 29, this was. And pag-uusapan po natin ito, katulad ng nasabi ni attorney, this merong epekto ito doon sa mga mag-apply ng cancellation of removal. Abangan mga kaibigan, because sa pagbabalik po ng ating Immigration Law on Your Side, we'll head over to a break right now. Pagbabalik ng Immigration Law on Your Side, we will talk about this Supreme Court decision issued on April 29 this year, mga kaibigan, para mabigyan tayo ng paliwanag ni Attorney Diza. So, dyan lang po kayo. Magbabalik po ang Immigration Law on Your Side dito po sa PHLV Radio.
Reeves Immigration Law Group has been representing immigrants for nearly 40 years. Reeves Immigration Law Group has been fighting for its clients through experience and expertise. With immigration lawyers you can access at reasonable fees even on Saturday. Payment plans are also available. Call us for your immigration solutions. We can do worldwide telephone and Skype consultations. Reeves Immigration Law Group, 1-800-795-8009. Reeves Immigration Law Group has offices in Los Angeles, San Francisco, China, and Philippines. See us at www.rreeves.com. Reeves Immigration Law Group, 1-800-795-8009.
All right, welcome back to Immigration Law on Your Side right here sa PHLV Radio. We're on every Wednesday, 7 p.m. Pacific, and that's 10 p.m. Eastern Time. Maraming salamat sa mga listeners natin dyan sa bandang East Coast ng Amerika and worldwide na rin, and especially dyan sa Pilipinas. Meron pong opisina ang Reeves Immigration Law Group dyan po sa Makati. And attorney, before we headed over to a break, we gave our audience a preview that there was this decision from the Supreme Court just a few days ago that might impact or might save a lot of immigrants who are deporting or are facing deportation. Attorney, mapaliwanag po natin sa kanila kung ano po itong desisyon ng Supreme Court na ito.
Yes, Kuya Yo, ang immigration community is rejoicing, and celebrating with the passage of this decision dahil as you mentioned, it will save and help a lot of immigrants who are currently in deportation or removal proceedings. Now, as we mentioned kanina, Kuya Yo, pag nag-issue ang gobyerno at ikaw ay i-deport, binibigyan po kayo ng notice to appear, single piece of documents charging you of the violation, right? Usually kasi ang applicants will be placed in removal or deportation proceedings, Kuya Yo, if they applied for a benefit, right, in the past. For example, they applied for an adjustment of status through their spouse, or through their parents, and for whatever reason it was denied, right? And then, of course, the officer at the Department of Homeland Security or USCIS will issue a denial and then issue a notice to appear, like especially nung panahon ni Donald Trump where, everybody, is a priority, right? Even if you're overstay or even if you have fraud or crimes or, had a denial of your applications. Now, what happened is that they issued a notice to appear, and because the Department of Homeland Security has probably no idea kung kailan yung next hearing or available ng immigration judge, because ang immigration courts, Kuya Yo, is under ng Department of Justice, right? So ang USCIS is under ng Department of Homeland Security. So once they issue the notice to appear from the Department of Homeland Security, right, they will not state the date and time. Right. But before we proceed with that, i-define lang natin yung notice to appear. Ang notice to appear, as we mentioned kanina, is a piece of document. It's a piece of paper, right? It's a document charging the non-US citizen or yung immigrant of a violation of a federal immigration violation. For example, overstay, fraud, crime, and they are requiring them to appear before the immigration judge, right? Now, on that notice to appear, it also requires the government to indicate kung kailan ang hearing mo at kung saan. So, when and where. So, they issue the notice to appear and where to appear on that particular date and time. So, most sa mga notice to appear na yun, Kuya Yo, walang date and time. Nilagay lang nila to be determined, right? So, nakatanggap ka ng sulat, right? Unang sulat, nakatanggap mo. And then may pangalawang sulat na naman na tinatawag na notice to appear, notice of hearing na, sasabihin sa'yo, for example, natanggap yung notice to appear in January 1, right, of 2010. Siyempre, hindi mo alam kung saan yon. Alam mo, nasa removal ka na, pero hindi mo alam kung saan. Di ba? Now, and then the following 6 months thereafter, nakatanggap ka ng notice to appear na. Sabihin sa'yo, you're going to appear in Las Vegas office at this address on June 10 of 2010. So meron ka ng subsequent notice to appear. So at that point, for example natin kanina ni Juan de la Cruz na 9 years pa lang sa Amerika, right, nung natanggap niya yung sulat, at wala siyang meron siyang nanay na qualifying relative sana who could possibly apply for a cancellation of removal, kaya lang hindi siya pwede mag-apply dahil 9 years lang. So nag-stop nag-stop na yung time. So when you question na yung notice to appear pala yan, the Supreme Court said this is the same situation in the US Supreme Court decision, Ms. Chavez v. Garland. Garland is the current Attorney General natin, right? Where it says that the notice to appear should come in one single document. Kasi ang sinasabi ng government, Kuya Yo, ang argument nila is that na-cure naman kahit defective yung notice to appear mo na unang final sa iyo na walang date and time, na-cure na yun yung subsequent na notice. Kasi nag-appear ka na, you submitted to the jurisdiction of the immigration judge. In fact, you already argued your case before the judge and you lost the case, you went to the appeal process, right? But the reality here, Kuya Yo, and the good thing about this is that nababaliwala yung decision ng judge ngayon kasi i-reopen lahat yan. Ibabalik ngayon, i-reopen yung case kasi defective ang ginawa ng gobyerno. There are thousands of notice to appear that do not contain or did not contain the date and time, right? And therefore, yung mga kababayan natin na hindi nag-asawa ng citizen or hindi 245I or yung mga kababayan natin nag-entered without inspection, right, would be able to avail of this Supreme Court decision. This is a very good decision dahil you give the benefit or the opportunity sa mga kababayan natin na i-reopen ang kanilang kaso. Kasi at that point, like sinasabi natin, si Juan de la Cruz, wala siyang relief eh. So wala siyang relief dahil wala siyang 10 years. So anong ginawa niya? For example, nag-avail lang siya ng asylum. Sasabihin niya, ayaw ko nang umuwi because I'm too old. I cannot find a job. Right? I fear of going back because my mom would suffer hardship kung hindi ako alis or kung pauwi na ako. But the reality is that was a very weak case. Right? But had he applied for a cancellation of removal at that time, he could have been a green card holder. So this is the good thing about this decision, Kuya Yo, because it opens a lot of opportunities sa mga kababayan natin to apply for a cancellation of removal or to reopen their case. So even if they already have a prior removal order, right, from the immigration judge and a decision from the Board of Immigration Appeals, and probably nakarating pa sila sa 9th Circuit Court of Appeals or kung saang circuit court sila, right, they're able to file a motion to reopen. So it's very important sa mga kababayan natin. From my case alone, Kuya Yo, I was super happy and excited nung nagkaroon ng decision na to because I have a case in Salt Lake City where, I was fighting for the notice to appear was defective. I mean, my client could have applied for the cancellation of removal, so na foreclosed yung kanyang opportunity to apply for that. And I fought that before the court, before the BIA, and then nakarating kami sa 10th Circuit kasi ang Salt Lake City or Utah is under ng 10th Circuit. So it's pending appeal. But there was a current, decision, or not the decision, but a case that was first filed as Supreme Court. Nakarating ito nga si Ms. Chavez, and we were saying that, we have to wait. Sabi ng government attorney, hintayin natin yung Supreme Court decision. So we suspended the case before the 10th Circuit and hinihintay natin yan. Kasi once the Supreme Court issued the decision, I contacted the government attorney telling him that, hey, we won the case and he should remand. Ibig sabihin ng remand, ibabalik natin ulit yung kaso either sa Board of Immigration Appeals para ibalik sa judge para i-hear yung kanyang cancellation of removal. That's a good thing about this case, Kuya. Kasi as I mentioned, I mean, my case has been languishing in the immigration court sa Salt Lake for about 5 years in 2000, if I'm not mistaken, 2012 until 17, right? And then ngayon, babalik na naman tayo doon to hear another case, and hopefully this time, my client has a better chance to get that approval. So sa mga kababayan natin nakikinig at nanonood at may mga cases kayo, you have to look at the notice to appear and probably consult an immigration attorney to evaluate, yung notice to appear, yung documents or immigration file, immigration court file to determine kung kayo po ay eligible ng i-reopen ang case and be able to apply for a cancellation of removal, which is, as we mentioned, thousands of immigrants are being or will benefit from this decision.
Mm-hmm. So mga kaibigan, mahalaga na kumonta kayo sa ating mga kaibigan from Reeves Immigration Law Group para po kumonsulta if you have one of those letters. At least malaman natin kung anong mga options ninyo para po mabigyan ng remedyo yan, kung paano. Attorney, in your experience, marami ba tayong mga kababayan na nasa ganitong sitwasyon?
Yes, Kuya Yo, as we mentioned, it's not only my personal case before the 10th Circuit Court. I mean, I have still pending cases with the immigration judge. If you remember, Kuya Yo, panahon ni Obama, right, there were admin closed ng cases. At that point, siyempre wala pang mga 10 years yung mga kababayan natin, and because, as we mentioned, na foreclosure yung kanilang right, walang relief. So what we did is, since they don't have criminal convictions or records, we closed the case because that was the priority of Obama administration at that point. So fortunately, hindi naman ni-reopen ng panahon ni President Trump. So hopefully ngayon, if we found out that they have a qualifying relative who would rather suffer extreme hardship if the case is reopened, then we will be able to apply for a cancellation of removal. So maraming mga kababayan natin, Kuya Yo, ng ganyang sitwasyon, at hindi lang yung mga out of status o walang asawa, yung mga sitwasyon din where people committed marriage fraud. Now, if we discussed in the past where a person is found to have committed marriage fraud, now even if they're now divorced with the petitioning spouse, right, and found a new family, right? Let's say may bagong asawa, may mga anak na sila, right? That spouse and children, if they turn 21, won't be able to petition for her or for the client. But the good thing about the cancellation of removal is not a petition. So if they are in court, right, then probably we can apply for the cancellation because wala namang prohibition even if person admit committing fraud, as long as that happened years ago and he has to prove good moral character now for the last 10 years and has a family who suffer extreme, exceptional, unusual hardship, then this is also a good relief. So as we mentioned, Kuya Yo, there are many opportunities and possible relief sa mga kababayan natin. Discuss your immigration situations or your family immigration situations and see if this new Supreme Court decision applies to you or will benefit you or your family.
A few days ago, nakita natin sa feed ni Attorney Diza ang balitang ito. Kaya makakaasa po kayo mga kababayan that we will always have updates from Reeves Immigration Law Group. So we repost that here, and we also talked about it in some of our other programs here at PHLV Radio. So manatili pong nakatutok para po malaman natin ang mga bagong balita galing sa tungkol sa immigration, kasi nakatutok po dyan si Attorney Felony Diza. Attorney, at this point, siguro ma-invite natin ang ating mga viewers and listeners na kumontak sa inyo. Are we still Zoom pa rin tayo ngayon, Attorney?
Zoom pa rin tayo ngayon, and we offer free consultation at this time, so take advantage of that. Partners are considering bringing back a consultation fee, but as of now, as we speak, wala pa huyaan. And sa mga kababayan natin, President Biden had just his 100 days in office, and we assess his immigration policies for the last 100 days. Marami po siya mga improvements, hindi niya tinaasan ang mga filing fees, which is very good. At tinanggal na yung public charge, which also helps sa mga kababayan natin. Yung mga missing information sa forms. Dati kasi, nung panahon ni Donald Trump, kahit hindi applicable sa iyo yung information na yun sa form, Kuya Yo, kung hindi mo finilapan yan o hindi mo lalagyan na not applicable, di-reject yan. So ngayon, tinanggal niya yan. And of course, very important yung DACA. But we're still hoping and waiting for the major immigration reform ng Pangulong Biden. Unfortunately, his hands are tied. I'm not sure if he's able to do an executive order, but he already sent his proposal ng immigration sa Congress. So we're waiting for that. Keep on updating yourselves. Check our Facebook page at Reeves Immigration Law Group. Meron din po kaming website at www.reeves.com. Subscribe to our newsletter para sa weekly updates po ninyo. I have also my personal immigration updates at FJ Diza, U.S. Immigration Attorney. You update yourself, and also, of course, if you think that a you need us to assess your case, feel free to contact our office, Reeves Immigration Law Group. We offer, as we mentioned, free consultation either by Zoom or by phone. We have office in San Francisco, where I am based, in Los Angeles, Makati, and China. And what do you call this? Yeah, it's still a free consultation to one of our certified immigration specialists. Maraming salamat, Kuya Yo.
And especially sa ating mga kababayan anywhere in the United States po, attorney, pwede po silang kumontak sa inyo.
Yes, anywhere in the US, and the good thing is we're getting a lot of clients through PHLV Radio. Maraming salamat, Kuya Yo, at our exposure are worldwide, nationwide and worldwide. We're getting clients from the East Coast, Midwest, right? And take note, mga kababayan, ang immigration is a federal law. So kahit saan po kayo, right? We offer free legal consultation, and we assist. We represent clients all throughout the US and all throughout the world with regard to your immigration matters.
Naku, maraming salamat po, Attorney Diza from Reeves Immigration Law Group. Nandun po sa San Francisco, California. Ako naman po nanggagaling dito sa PHLV Radio Studio sa Las Vegas. Si Kuya Yo po ng PHLV Radio Las Vegas. We are live also on our website, www.phlvradio.com. And sila attorney, ang kanilang website, www.rreeves.com. And of course, on our apps and our social media pages. So maraming salamat po sa pagtutok sa Immigration Law on Your Side. We will see you next time. Dito pa rin sa PHLV Radio na nanggagaling po sa Las Vegas, Nevada.
Reeves Immigration Law Group has just brought you Immigration Law on Your Side. Wednesdays, 7 p.m. Pacific on PHLV Radio.
Just like a friend from back home.
Hi everyone, this is Lana Misalucha and you are listening to PHLV Radio.
PHLV Radio. Just like a friend from back home.
Hi, this is Gary V. Listen to a Filipino radio experience right here in Las Vegas. PHLV Radio.
PHLV Radio.